stuck with this laptop webcam.
I'll be able to use the slides, the other button to run the.
Yeah. I'll share it in just a moment.
Thanks.
In fact, I will share it right now. There we go. I hope you can all see that. Wonderful. Well, without further ado, can I thank you all for coming. Good afternoon to those in person and online. I'm Dr. Jonathan Kolieb, co-director of BHRIGHT, the RMIT Business and Human Rights Centre. Welcome to another BHRIGHT research seminar. Today, we are honoured to have with us Dr. Ekaterina Aristova, or Katya, as she is being called, to share some insights on the evolving nature of the duty of care of companies through the lens of strategic human rights and environmental litigation. In Australia, such human rights and environmental litigation often involves Indigenous peoples as plaintiffs, alleging violations of their rights as the basis of the lawsuit. And so it's fitting, as we kick off this seminar, to also acknowledge the Wurundjeri people of the Kulin Nations as the traditional custodians of the land on which the university stands and where we are meeting today. We respectfully recognise elders of all First Nations people, past, present and emerging, including those that may be joining with us today. We acknowledge and support the continued efforts of the Indigenous peoples of these lands for recognition and for the enjoyment of their rights, and for reconciliation for all people who call Australia home. The evolving nature of companies' duty of care, as demonstrated in human rights and environmental litigation, is a topic that crosses both law and business disciplines. It's a hallmark of many of the activities of BHRIGHT members. So we are excited to hear about this super interesting topic. It's interesting from a theoretical legal perspective, I think, but also from a very practical risk management, business-oriented perspective as well. Now, who better to talk to us about these developments than Dr. Ekaterina Aristova, a colleague I was very fortunate to meet, I think over 5 years ago now.
In 2019, around the UN Forum on Business and Human Rights.
Pre-COVID.
Yes, pre-COVID, yeah.
Dr. Aristova is a respected member of the global business and human rights academic community. She's a fellow at the Bonavero Institute of Human Rights at the University of Oxford in the UK. She's got a deep interest in the field of BHR, business and human rights, and has focused her research in recent years around strategic human rights and environmental litigation. Dr. Aristova is the co-editor of several volumes and has a new book out just this month.
The 25th of April coming out.
There you go. Based on her PhD, is what I understand, about tort litigation against transnational corporations, the challenge of jurisdiction in English courts. Thanks for coming to Melbourne. Thanks for coming to BHRIGHT. We're excited to hear from you. In terms of how we'll proceed, we'll have Dr. Aristova's presentation. We'll take some questions. We want to be respectful of everyone's precious time, so we will wrap up kind of strictly at 1:30.
Yeah.
And then for those that are in the room, please welcome to continue the conversation over tea, coffee, and some yummy Monte Carlo cookies. So without further ado, Dr. Aristova.
Thank you very much, Jonathan. And the beauty of BHR community is we are expanded, but still rather small groups. So if you meet with people even 5 years ago, pre-pandemic, still keep this relationship and follow each other's work. So it's a great pleasure to be here today. And thank you very much for having me. As Jonathan said, he already kindly introduced me. So I'm part of the Bonavero Institute of Human Rights in Oxford. This is a dedicated institute within the Faculty of Law at the university, and my colleagues run a number of research projects and student programs in the broader areas of democracy, rule of law, and human rights. And I lead the work on the business and human rights and everyday life, probably as many of you. I look at how corporations should be held accountable using international, domestic mechanisms. And I'm particularly interested in strategic human rights litigation and big landmark cases that arise following some mass disasters, usually which are brought by the local communities, indigenous people. So very much looking at the issues that you've highlighted. And I'm going to speak today about the article I'm working on, so present an argument. I'll just slightly later say what it is that I'm trying to achieve. But I want to start with this statement, infamous statement, I will say, that many people will probably know, by Milton Friedman, an American economist and a Nobel Prize winner, who said in 1962 in his book, and then reinforced this statement later on in the New York Times article, which is available online and generally interesting read. And the statement he made is that the only responsibility businesses have towards society is to make profits. So it's all about money. And for quite a while, this has been really a paradigm within which business was operating. And it was all about the profits, all about money. But things have changed. We are now living in a very different environment where multinational companies have grown up. The impacts of their operations have grown up as well. And this profit-making paradigm proved to be unsustainable. But this is a different statement that has been made 57 years after Friedman's statement, has been made by US Business Roundtable, which comprises nearly 200 CEOs of America's largest companies. And they adopted at their annual meeting a statement saying that actually the purpose of corporation is to serve broader community. And we do have multiple stakeholders, customers, employers, employees, suppliers, communities, and we all share a commitment to all these stakeholders. So the message between those two statements is quite different, from we only make money, we don't care about anyone, to we actually do share commitments to people. And obviously this statement has been not made in the vacuum, in the regulatory vacuum. 57 years between these statements, we have seen many initiatives, including at the UN level, started from the UN Code of Conduct, UN Global Compact, of course, UN Guiding Principles on Human Rights, but outside UN initiatives, also soft instruments like OECD guidance for multinational enterprises, which have been just updated last year in 2023. And what we do see now is there is a pressure on corporations to consider, in addition to their profits, also the impact of their activities on different stakeholders and the environment. And since 2011, when the UN guiding principles have been unanimously adopted, there has been globally acceptance that business do have responsibility to respect human rights, to do something more than just making money. And we also see recently that, in addition, legislation has been adopted that supports those soft instruments. Modern Slavery Act in Australia is probably one of the examples, but we do also see harder legislation in the EU where reporting requirements are now also supported by stronger enforcements. An important part of this changing framework in which corporations operate is being strategic human rights and environmental litigation. Cases arise all over the world. Litigation in the global north has been particularly prominent and maybe well discussed, but there are also very interesting cases happening elsewhere. And there are different impacts of this strategic litigation. There are both positive impacts, negative impacts. And this is something I've been studying in my work quite a lot. It's like, well, what is this all about? How do we assess the impact? Is it just winning in the court? Is it a courtroom victory, or it's going beyond driving some social change? And there have been very different expert opinions. Some people say, yes, litigation is very important. We do have so many landmark decisions, and communities have actually access to remedy, even if it's not always everything they need, but at least something. To also quite negative views on, well, there are limitations. Private claims cannot solve the problem. It's usually symbolic compliance, and there are risks of counterclaims where human rights defenders will be facing those risks. So this is something I've been looking at, and I thought that rather looking at this just sort of particular case studies and particular efforts that individual decisions have. Why don't we look at the longer period of years of litigation and see, well, in this several decades of litigation, what is the impact, this long-term impact? How litigation contributes to our understanding of the purpose of cooperation or this duty of care? Does it actually contribute to changing our understanding about what is responsibility of cooperation? So this is the article I'm working on at the moment, which looks at 3 different case studies. The one is about civil liability of parent companies and corporate groups. The second, primarily first case study concerns litigation in England. Second case study focuses on human rights due diligence cases under the French duty of vigilance law. And then the third case study is probably the most emergent one, still at this very novelty of issues it raises about corporate duty of care to mitigate climate change. So I'd rather briefly go through, not briefly, but go through this case studies to see, well, what are some of the lessons that we can learn from that. And I want to start with another citation, going first to the first case study about corporate groups and parent company liabilities. Nicholas Butler was the president of Columbia University. And in 1911, he made the statement that limited liability principle was more important than steam and electricity. It's quite a big statement, but I'm sure many of us studied corporate law as part of the undergraduate studies. And one thing we all learned is that limited liability principle is one of the major principles that brings corporations to an effect. And for quite a long time, limited liability was an absolute principle. It was an untouchable one. But of course, limited liability principle was developed in 19th centuries for one-man companies, where an individual shareholder would establish a company, and to secure him from the debts of that company, he would be only responsible for the share of his stock of his own investment. And whenever something happens with a subsidiary, the shareholder will not be responsible for its debts. But corporate groups continued to grow, including beyond the borders. And if you look at major multinational companies now, they have thousands and thousands of subsidiaries. And it became quite a pattern for big corporate groups to not just rely for the benefit of limited liability principle, but to some extent to abuse it by setting a particularly hazardous activities and operations with a subsidiary elsewhere. And whenever something goes wrong, and it's a gas explosion or oil pollution or something concerned with the forced labor, the supply chain liability, the companies will usually rely on limited liability, saying, well, we are the parent company, we don't have to do anything with that. It's all about what subsidiary did. And for quite a while, the problem to this decision, the solution to this problem was seen in peace in the corporate world. When I did my undergraduate studies a while ago, it was all about peace in the corporate world, but it didn't prove to be successful. And in 1994, an English lawyer, a partner at the company called Liday, Richard Merron, have thought, well, what if we don't look at corporate law and peace in the corporate world? What if we look at tort law, a duty of care, and try to establish that a parent company has a duty of care under tort law to the employees of its subsidiaries or local communities which live around it, if it is involved in the subsidiary's operations and somehow exercises control and can foresee this risk, and should have known about those risks. So it was quite an innovative argument based on tort law. And Richard Merron and Liday brought 3 cases around the same time. Labo versus Cape was one of the cases that reached House of Lords. It was brought in 1997 by South African citizens who worked in the subsidiary of the Cape Group in South Africa, but they brought a case against the parent company. They were suffering severe health injuries due to asbestos exposure, and they said that it was actually Cape PLC, English parent company, responsible for those injuries because it inadequately set the health and safety procedures at the subsidiary level. So it didn't take enough care to set everything properly and to supervise it and to have enough care implemented at the subsidiary level. The case was litigated for several years, up and down the UK system on the issue of jurisdiction. And as soon as the House of Lords said that the case will be heard in England, defendants settled the case. But the House of Lords made one very important statement, even though we didn't look on the merits of the case. So, well, resolution of the parent company liability issue will likely involve an inquiry into what part the parent company played in controlling the operations of the group. So even though we didn't look at the merits, it didn't completely said no or rejected the argument. Richard Mirren wrote a book recently, a couple of years ago, where he said that this creative argument was discussed with one of the barristers, Queen Counsel, and a judge, and both were very pessimistic about that it will never go ahead. But luckily, for some of the communities and luckily for the business and human rights experts, Richard and his team continued to work on those cases. And after Labour versus Kolieb, they brought for about 30 other cases. I won't tell about all of them. I will tell just about one. Langdover versus Vedanta, probably one of the most famous cases on this issue that also reached the Supreme Court of the UK. It was brought by the Zambian citizens who are living near the mine, which is operated by a company called KCM, and this is a subsidiary of Vedanta, the English domiciled parent company. And this local community are fishermen, farmers, and they rely on their rivers, which are polluted heavily by the mine operations. So they brought a case against Vedanta, saying against similar issues that Vedanta, as the majority shareholder, manages operations of subsidiary. It resolves its budget issues. It says how much money is allocated towards environmental protection, health and safety, and it didn't take enough care to respond to those issues. And in April 2019, UK Supreme Court confirmed jurisdiction. Again, was jurisdictional case. But what the Supreme Court said was very groundbreaking decision. It says that, well, actually, imposing a duty of care on the parent company is not a novel or controversial issue. It has to be resolved as any other case involving negligence. So if the parent company is really involved in the operations of the subsidiary, if it's actively involved, if it issues group-wide policies and their implementations, if it trains subsidiary employees, supervises them, provides some advice, even if it makes statements but doesn't stick to them, it can be held liable for the breach of duty of care. And of course, that's a very important message to be sent to companies, that limited liability is no longer an untouchable principle. Yes, it's a still major principle of corporate law, but you can be held liable for the breach of duty of care if you are actively involved in the subsidiary's operations, and this involvement can be linked with some of the adverse operations. So that's case study number one, over 30 years of litigation, and we go from we are not responsible at all for the subsidiary's debts to actually there are some very important risks there that you need to take into account. I'm moving now to case study number two, and another quite famous statement. So the first case study that I've just told you about by the parent company liability was all about private law and tort law, etc. But it has been the puzzle for lawyers and for commentators for a long time. Well, can you actually hold corporations accountable for human rights violations per se, not just for negligence or for not taking care under private law, but for human rights violation itself, because it's quite important message to be sent as well. And the solution has been, people were looking for the solution in international law. How do we extend international law responsibilities to corporations? That, of course, proved difficult because corporations do not have international legal personality. And international treaties, including international human rights treaties, bind states as main duty bearers. And the concept of international law is state-centric. And as a result, when we talk about human rights violations, we usually talk about corresponding state responsibilities. There have been attempts to impose direct international legal obligations in the field of human rights and corporations, but they have proved to be political. They ultimately failed. UN is still trying to negotiate the UN Treaty on Business Human Rights. I'm not sure Jonathan is smiling. He shares my pessimism as well as to how close we are to this solution. But anyway, there has been long debate about, well, can you make corporations accountable? And some states now thought that, well, if you can't do it via international law, what if we try to do it via national domestic legislation? And it has been a move towards what we called mandatory human rights due diligence, trying to establish and set a range of obligations for corporations to respect human rights and environmental protection under national laws. French duty of vigilance law is still one of the most famous and probably the most important act on its own, but it has led to similar legislation enacted elsewhere in Europe. And actually, we are in the process of the European Union adopting the wider legislation on human rights due diligence that will bind all European companies, and well, that will be implemented by all states in the European Union. But let's talk about the French law. So it was enacted in 2017, and it imposes an obligation on the largest French companies to establish and effectively implement what is called vigilance plan. And in this vigilance plan, they need to identify all human rights violations and environmental damage that can arise in their own operations, in the operations of their subsidiaries and supply chains, but also talk about how they're going to prevent, address this damage, and how they're taking care about it. If I'm not mistaken, so the last time I looked, and the French law binds just over 200 large companies. So it's not still the major number, but still it's an important step. And the law has a twofold enforcement mechanism. So first, any interesting party standing, including civil society organizations, can apply to court if the vigilance plan is not adequate, or if, for example, the company that is meant to have the vigilance plan did not adopt it. And so the court can issue an injunction making company to adopt the appropriate plan. And then the second stage is when actually a damage has been caused and the party can prove that the damage, the failure to comply with the vigilance obligations is linked to this damage, and it could have been otherwise prevented if the company complied with the obligations. Then you can bring a civil case under French tort law, French civil code. One of the first cases that have been brought under this law is the case by Friends of the Earth against Total in France. It's been litigated for several years. 6 civil society organizations challenged an oil project that it involved building a pipeline which will run through Uganda and Tanzania, and it will run through the territory of the natural park, which is a protected area. And the project already, at the time when it already involved displacement of several communities, which can be, we can talk about land grabbing and all of those issues. Still, at that point, there was nothing in the in Total's plan about this project. They didn't even say anything about it, even though it already led to some of the consequences. But also, their argument is that the pipeline will have an impact on local communities and the environment, that they will not be able to survive in this environment if the project is implemented. Unfortunately, the court dismissed this case because it was inadmissible on procedural grounds. And there are now about, again, just over 20 cases that have been brought under French duty of vigilance law. Probably the most interesting at this point are the 3 cases that you can see on the slide. And these actions were also declared inadmissible in their first hearings. But then, in an important move, the French courts established a separate chamber that is now dealing with all of the cases that arise under the French duty of vigilance law. And in the appeal hearing, they united these three cases as the most advanced one, and they had a oral hearing on 5th of March, and the decision is expected in June 2024. So what is the lesson that we can sort of retrieve from this case study? Yes, it's still a challenge to link corporations directly with the human rights responsibilities. Yes, we're still sort of on the way to establish an appropriate framework about corporations and human rights responsibilities. But we do have at least already one example of law that led to similar legislation adopted in the EU states, and now will be EU-wide in few years. But we also, the implementation since 2017 led to a separate chamber, a separate court in the judicial system that now exclusively deals with the issues of corporations and human rights. Again, if you look at it, just private actions, but if we met 10 years ago, like even when we met with Jonathan in 2019, the implementation of the French law was just at the very infancy. So nobody would think that it will lead to having a separate chamber leading dealing with those cases. So again, we can see that there is some of the developments, positive ones, even though it takes long and it goes through some losses, but still quite an important development. My last case study is about climate change, and I have a citation from Paris Agreement, which was adopted in 2015, and states all over the world agreed to reach a long-term temperature goal and to take action to implement it. Paris Agreement, again, as all international treaties, only binds states. But for quite a while, environmental activists focused exclusively on states and state obligations in relation to climate change. But there has been some very important science developments which have attributed gas emissions to major fossil fuel companies, and even attribute some of these emissions to particular weather events, whether it's floods or bushfires. And what the litigants and environmental activists have been thinking is, well, how do we translate this scientific knowledge and everything that we know about now corporate responsibilities from the previous studies? How we now make this link to climate change? One of the most interesting cases, most discussed, famous, is a case in the Netherlands, which was brought by the environmental organization Litigation against Royal Dutch Shell in 2019. And the allegation is that Shell contribution to climate change violates its duty of care under Dutch Civil Code. Again, this is a private action, but the way Dutch Civil Code operates, it allows to interpret existence of duty of care with the reference to what they call unwritten social standard. And this unwritten standard can be interpreted very broad, and indeed has been interpreted very broad by the court. And in 2021, the Hague District Court ordered Shell to reduce its emissions by 45% by 2030. And it said that this duty of care arises because of the Paris Agreement, UN Guiding Principles on Human Rights, and European Convention on Human Rights. This case was appealed. Appeal hearing started last week. Shell is defending challenging the case on multiple grounds. One of the grounds is that the target, the temperature target, and the reduction of emissions targets is set for the states. And corporations are not bound by it, and you can't, in a private case, make a link to the Paris Agreement and human rights obligations which bind the states. But the second ground, one of the grounds that they do, is also quite often used by the corporations. It's called market defense substitution. They say, well, if it's not us, there will be other fossil fuel companies which will do the same. Yeah, exactly, which will do the same. So you can't bind just one company. You need to bind all, and that's not the court's responsibility. It's the legislator. They need to do that. So the climate case, probably the climate case studies, it's in the most infancy, and this is where we still don't have many of the definite answers or decisions, partly because so many decisions are still going ahead. But Shell case was reproduced in Germany unsuccessfully, but still there are similar cases running in Italy, in New Zealand, a case against the company for the novel tort to cease climate change, Smith versus Frontera, and all over the world the cases that arise. So it's definitely not the end, and we'll see more and more litigation happening. And I get to the conclusion and sort of to what is it that I'm trying to say with this article is that yes, litigation landscape is muddy and uneven. Yes, we've seen some victories, big victories, but we've also seen some setbacks, including in the US. I haven't talked at all today about the US, and we've seen litigation there under Allen Tor's the Tort Claims Act, which was unsuccessful and effectively closed the door to claims against multinationals. So it's not all, rainbow unicorns in this. We do see some issues, but it's a long journey. And litigation is certainly contributing to hardening the standards on corporate responsibility. And it's been an important vehicle in implementing the requirements that in the UN guiding principles. And I think the conclusion what I'm trying to say is that yes, it's a marathon. We have to look not just at the landmark cases that can be won or can be lost, but we need to look in the years. What is the longer impact, and how is it changing our understanding? Does it contribute to some of the normative foundations? And I think if we can establish that, then we probably need to accept that litigation is a necessary stage, an essential element in this regulatory landscape. I'll stop there. If you have any follow-up questions, and it might be like it's a bit a lot that I've put for you. So if you have any thoughts, follow up in a week, in a month, in a year, please get in touch. And I'm looking for the feedback or any questions. Thank you.
Yeah, thanks very much. I'm going to stop sharing.
Absolutely.
And so then we can all see one another.
Can you say photo? What about this one?
Just for a minute. Okay.
And can you, sorry, the front page?
Just one.
I just need to try that again.
All right. Thank you so much. We've got plenty of time for some questions. Here we are. So let me just throw it open. I'll monitor the chat box, but please, even if you're online, if you could raise your hand also, and we will monitor that too. But any questions for Katja? Yeah, please. This is, can I introduce, and Dr. Anne Callies is our new co-theme lead at BHRIGHT for climate change and environment. So, get ready.
We did look at, we wrote a paper actually under, to look at law and whether you can use it to get to corporates to overpromise. Basically, can you hold them to we will be net zero by or something, and decided under Australian law at the moment you can't. But my question is, on that topic, are you looking at the very rich case law on directors' duty?
Yes. I'm looking at, not for this article, but so I've been doing several projects on strategic litigation over the last several years. And so this article that I've presented is more of the synthesizing the knowledge I've had and sort of bringing together some bits. But the most recent project that is undergoing at the moment is about climate change litigation. And I'm working on a few pieces in relation to that. So I've published something on greenwashing last year, something about OECD guidance on climate change is coming out in April as well, the International Comparative Law Quarterly. But I also co-wrote with one of the barristers who's happens to be my husband, an Australian as well, English, who works as an English barrister now. We wrote an article and submitted it last month about directors' duties and client F case versus Shell in England. So this is a very interesting case, a very big case. Last year, client F brought a case against 11 directors of Shell, saying that they breached their duties under Companies Act in England for lack of adequate climate change policies. In effect, the central allegation is the policies are inadequate. Shell will not reach net zero target. It's not taking action enough to stop investment in fossil fuels, etc. And for these reasons, directors breach their duties. What the court said is that we're not going to get involved in the managerial decisions because it's about the shareholders and the directors to agree on those issues. Actually, the directors have a strategy. They put it up for the adoption by the general shareholders meeting, and the shareholders adopted, and they said, well, you need to tell us what directors did wrong. Did they were fraudulent in their actions, etc. So that case was not successful, but it certainly will get further actions. And there are some other cases going around the world against directors on the procedural issues about whether they're handling climate change and the risk properly. So the conclusion we make is that even this case was not successful. We probably will see more and more cases against directors.
This is big in Australia, shareholder.
Yes, because you have quite interesting cases against ANC Bank for some procedural management.
Many get settled actually.
Yes,
anywhere. Unfortunately,
yes. That's quite interesting. But I also wanted to can I just make a point about what you said about for the statements, net zero emissions, can you bring total or etc. Because it has been this opportunity discussed in the broader BHR movement again in relation to modern slavery statements. Australian Modern Slavery Act, in UK we have a Modern Slavery Act, and the UK Act was called Tiger Without a Teeth, because companies are required to issue modern slavery statements, but there is no enforcement of either if they comply with it or if they don't comply with it. It's actually there are only 3 requirements. The modern slavery statement needs to be signed by the director, it needs to be approved by the board and made publicly available on the website. So technically the company complies with these 3 requirements, but says, yes, we are aware there is modern slavery, but we're not going to do anything with that. Technically, they complied with this. You can't do anything. So there has been discussion, and I know some of the colleagues as well who thought about it. Well, can you actually bring just a conventional civil action for breach of statute? So I know that there is some discussion. We yet to see whether it can prove to be feasible or not, but it's an interesting topic.
It's remarkable how little the legislators are doing. I mean, it's good to see the French law because we don't often. I mean, this is a very, I don't know, Anglo-centric worldview, mostly because we don't read French. I think.
Yes.
There are no legislators, and the French don't publish in English.
Yeah,
that's the other point.
Let's blame the French.
It's always good to blame the French. So, yeah.
Sheldon, please.
No, you go ahead.
No, go please.
Hi, thank you so much for the presentation. My question is about the, on its way anyway, corporate sustainability due diligence directive, the EU directive that has at least been approved by the European Council. And what direction you think that's going to take things in terms of?
Well, hopefully it will be adopted. I hope that people online can hear the questions from the audience. So the question was about the directive. So it has been now obviously approved by the European Commission and the Council. There has been some differences. The initial draft was a lot more ambitious. It included financial institutions. I think they're now out of the picture as well. There have been some compromises made, but it looks like the political deal has been reached. We're still awaiting approval by the European Parliament, which, if I understand correctly, again expected at the end of this month, hopefully. And I don't think civil society organizations see any problem with that. But once it's adopted, because it will be a directive, then states have 2 years to implement it via national legislation. So some of the major points will be there, that it will be enforced by civil liability. It includes a requirement for companies to adopt an energy transition plan. Although that's sort of not part of the human rights due diligence obligation, it's a separate article, but still we can expect more statements about net zero targets and more ambitious statements as well, which again gives more discussion how to enforce that. And then probably so 2024, if it's started from 2027, companies, some of the European companies operating largest will have those obligations. But I've been talking to many organizations, including not just in Europe, but outside of Europe, and they're really looking at it as an opportunity for more cases, for more interaction with the companies, for more engagement with the companies, because that will certainly lead to some of the disclosure of the things that probably are not disclosed at the moment. So I think that's, there is a lot of discussion again about whether so much focus needs to be put now just on human rights due diligence, because obviously it won't solve any moment all the issues. And Professor Surya Deva, who's very active in this area, has written a lot and very interesting, makes points about, well, we need to look at the deeper questions about purpose of corporations, business model, just going beyond just the requirements, hard law requirements. But yes, I think people are looking at it as a very promising development, but it's also the question is how it will be implemented. It's always the devil is in the details, whether it will be a tick boxing exercise, symbolic compliance. So hopefully there will be some sort of administrative enforcement as well, because the French law at the moment is driven the enforcement primarily by civil society organizations. We have to monitor all of the plans, we have to bring actions to fund those actions. So we'll see.
Questions? Anyone online? Just put your hand up. Oh, I've got a bunch.
Yes.
So I'm curious, Katja, your perspective. You know, you started with, I think the first case was 2000, your second one 2019 time. Yeah, it's a marathon, not a sprint, you conclude. And so I'm just curious on two levels, so two-parter. Is that sufficient? Is that adequate? And I'm thinking of the victims, the actual individual plaintiffs that are bringing these cases from their perspective. So I just wanted your reflections on just the sheer time it takes to run this litigation. And then I mean, there's some appeals going on, and where maybe 2024 will turn the car around. But do you agree that all these litigations get a failing rate? So like I go back to perhaps where you started about have we actually made change? How do we measure the impact of this litigation? The majority of the cases that you've referred to have been dismissed.
Yeah.
Or settled is the other. So in terms of advancing the law or even advancing victims' rights to actually access remedy and achieve remedy, do you maybe agree with the devil's advocate suggestion that it all gets a failing grade?
I think so. I think it gets to, there are so many levels to answer your questions. I think there are certain limitations to litigation. It's costly, it's long, you know, it's usually only big cases get out. So there are many cases that don't involve mass torts and thousands of victims that don't even get to the court because they don't have chance to be framed in a successful argument. Some, you know, security issues, some cases just do not get in because the claimants don't want to do it, because they're afraid of it, scared. Remedy, most of the cases about finances and compensation, but when we talk about Indigenous people, their laws often cannot be translated in money. It's a different type of nature of the remedy. So for all of those reasons, strategic litigation is not an answer to everything. And I think I'll always sort of, when I have to answer these questions, I like to say it in a way, but what is the question that we're asking? Is it a panacea? No, it's not. Is it important part of the landscape? Yes, it is. Does it have some advantages? So what is the alternative? Do we not do those cases at all? Because, you know, I've talked with Lide quite a bit about it and sort of voicing those limitations as well. And they said, well, you know, if we can help at least some communities, because if we don't do it at all, then it means that even those people who can actually get a settlement, and they've reached some very, very good settlements. But it's also, again, about the involvement. So what Lide has been doing in the latest cases, previous settlements were all just about the money. Now they're doing some creative settlements where they make companies agree to do some community services, whether like change infrastructure, build new roads, set educational centers. So do something just beyond giving money. And that has happened at least in 3 cases that I know in Africa and Latin America. So that's been a new step as well. So don't want to be all super proactive and say that, yes, we should go litigate. I think especially, for example, with the climate change, I think that now it's getting to the level where we need to sometimes stop ourselves and think, well, is it still going for good, or now are we creating some bad precedents? But I think it is an important part of the landscape. Another sort of layer to that is, well, how do we measure impact? What is effective, what is not effective? There has been a great report issued last year, which was commissioned by Freedom Fund, and it was written by Justine Nolan, colleagues in Australia, and Surya Diva, and they talked about all of those issues, and they offer some of the criteria. How do you measure impact? And it's not just, you know, contributing to direct victory, but it's also awareness and you know, forcing some corporate behavior. They look at different studies, they conducted interviews. I think it's worthwhile read all the cert, but they also talk about limitations as well.
Oh, so many things.
Oh yeah, there's
Darren, you got your hand up? Your
Yeah.
virtual-
Yeah,
Go
let me
for it.
turn this. Look, I'll be the devil's advocate. I'm pretty good at that. You began with the great Chicago School, you know, quote, and you're sort of suggesting things are a bit different today. I just want to tease that out a bit more, particularly how you've set it up, and presumably you're thinking about setting it up that way in terms of the paper as well. Given the state of corporate profits today, growing inequality, and the environmental crisis, I guess my question would be, what's changed? And even, you know, some of the cases you've presented there, you could actually look back at some historical cases, you know, decades or centuries ago in some cases. We often present that things have changed, and I'm not suggesting that they haven't, but it does force us to, you know, reflect on, given today's situation, the state of inequality, corporate profits, climate crisis, environmental crisis. Have we really moved beyond that sort of Chicago school thinking?
That's a great question. I mean, and it's very difficult to answer, because lots of corporations, what they do is it's all about symbolic compliance as well. We talk about the UN principles and, you know, about those net zero targets as well. They do issue those ambitious statements to please the investors and customers, or as a requirement of stock exchange, etc. So on one hand, yes, I do probably agree with you that if we have to measure that, then the success is relatively slow, given that also, as you say, inequality, and with the pandemic, and now also sort of the the range that multinationals of the adverse impacts, like contribution to the war crimes as well. Like how do you measure that? I think that ultimately that's also not for the courts to address all of those issues, and it's again coming back to the limitation. And if we talk about those issues, they're all coming to political decisions, and that's probably why the treaty on business and human rights has been not successful, because lots of those issues that we discussed, they probably need addressed either via international law or via very strong legislation about referring to that. And ultimately, the politicians are not always interested in that as well, per se. So I don't have answers to to the question. It's like, how do we solve that? I guess it's we just do whatever we can using different avenues. And yes, in Europe, the focus has been on this human rights due diligence legislation. There have been also devil's advocates saying, well, it won't solve the issue, it won't make big change, etc. But that's still sort of quite an important bit, I guess. Like for me, I'm thinking about, well, if you met 10 years ago, we wouldn't think about this even. We wouldn't think about that you can bring a case against the company for the violation of duty of care to cease climate change or to address climate change. So yeah, ultimately there's a very small steps. Maybe they are too small before we face major crisis, another one after pandemic, but I don't know, Darren, do you have any sort of questions on answer to your question or any thoughts about solutions?
No. I was just, thinking about in terms of how you set up the paper and with, you started with that, dreadful quote. But the reality is that, in thinking about particularly corporation, we know that many of them are prepared to take the risk of doing the irresponsible thing, and facing the litigation if it means they don't have to forego the profits associated with that irresponsibility.
Yeah, that's probably as well. Yeah. So if we talk about the settlements, the one of the major settlements Shell had in England in 2015 in relation to oil pollution was 50 million. Yes, it was 2050, but what is 50 million for Shell in terms of the and the pollution still continues, and there hasn't been a solution. And I know that now the community is bringing the case again in relation to the same incident, saying that it wasn't cleaned up. So it probably will be another few millions sent for that, but it ultimately doesn't change actually the pattern.
To maybe respond to Darren as well. I mean, one lens of looking at the human rights due diligence laws is that in a way it's giving corporations more agency. So it's making corporations the hero or the answer to these problems. And you can look at it as, I mean, one of the points of continuity is this cleavage between the economic south and the economic north. So when you look at the failure so far to get the business human rights treaty up, it was put forward by South Africa and Ecuador, and it's the economic north that isn't supporting it. And it's not supporting it because it's supporting its major multinational corporations. And that treaty has a really long history in terms of their early efforts in the post-colonial period for a transnational code for transnational corporations, and the kind of subsequent failures and the Ruggie mandate being looking for a compromise when previous failures to gain liability, which is what was sought. It wasn't a code, really. It was looking for liability, some form of accountability from multinational corporations domiciled in the economic north. And so in some ways we can say things have changed, but on the other hand, the dynamics between the economic north and the economic south and the incredible kind of freedom that those corporations still being given by their states, the states where they're domiciled, continues. And while these cases that you've looked at, I mean, while it's great that they're occurring for people in the economic south, within the economic north, it's the chances of any community from the economic south bringing a claim of this nature is just so limited. I mean, in my research, all the things that have to happen for a community to gain legal representation, it's incredible what it takes for a case of that type to actually make it to court. So looking at it from that perspective, you could say not much has changed.
Yeah, absolutely. And I think you have a very valid point there, which I'm trying to avoid as well in the paper, but it is in there, and I've written about it. It's about neo-colonialism and, even traditional imperialism. If they're talking most of these cases about global north deciding what has happened in the global south and how the adequate remedy should be and what the company should do. There are very also strong voices from the global south community now against human rights due diligence, or not against, but sort of putting this an argument that it's also a form of, in a way, neo-colonialism, and it's, what is human rights due diligence? Why global north decides what is human rights due diligence when it comes to the operations in the global south. So it's a big, on its own discussion, which, quite sensitive could be as well. So, but needs to happen, which is because of the reason I'm saying when I'm avoiding, I'm not discouraging it, but it's just that it unveils the whole new debates.
Following on from Shelley's comment and intervention, you mentioned, Katja, in your presentation that you've spoken to lead aid lawyers. I'm curious, do they ever share how much it costs them to run a strategic environmental or human rights litigation? Can we actually put a number on?
Yes, a few millions. So it's millions and millions we are speaking. So what I understand from some of the informal discussions as well is that the one of the reasons why they were able to afford it is that they're actually a personal injury firm, and the claims that they're doing, they're part of the international department. They're small parts of the cases they're doing lots of medical negligence, road accident negligence, lots of just sort of simple domestic, not simple, but sort of conventional domestic cases that actually bring money. And the way the business model works is that they were able to allocate money. But then once the international department became successful, now after several settlements, etc., they were able to recover the costs that fund new cases, etc. I don't think they're doing much work with external funders, but I won't say, but I think they're exploring this in particular with trying to bring maybe climate changes. But yeah, that's how sort of the model operates, but it's very expensive. Yes, it's because it's not just the cost of litigating in England, which can be to millions and millions, but it's the cost of preparing the case, because how many fieldwork cases you need, it's all translation, it's all experts, and we're talking about jurisdictions where it's not so easy to achieve as well. So
yeah, lots of practical, but also for the lawyers that want to represent.
Yeah.
I'm conscious of time, but is there any last minute burning questions online or? All right. Well.
Thank you to you. Maurice says thank you for attending. Thank you very much.
Thank you so much. So another round of applause, please.
Thank you. Well, I do have lots of notes taken as well, which will all go with the feedback as well on the paper. That's the beauty of doing research, where you can actually talk to people and think about the feedback and incorporate it. So
thanks for coming along.
Thank you very much.
And, please feel free to come along whenever you want.
Thank you very much.
In Melbourne.
Thank you.
Thank you all for those that did attend online and in person. For those that are in person, please tea, coffee, and cookies. Yeah. Thank you very much.
I saw you walking all the way up there.
No, I can't see you.
Oh, that was interesting. That was exactly the feedback I was hoping to get.
I've been thinking about